Can minority family shareholders stop unfair treatment in the business? Imagine investing your hard-earned money into a family business and then feeling pushed aside or treated unfairly. It can be frustrating, but there are ways to stand up for your rights. Minority family shareholders often have limited voting power and control, making it tough to change decisions. But they do have legal rights that can help protect them from unfair treatment. These rights include the ability to receive fair economic benefits from their shares and to take part in key business decisions. They also have a fiduciary right, meaning they should be treated fairly and not be subjected to oppressive actions by majority shareholders. Oppressive conduct could mean being excluded from important meetings, denied rightful benefits, pressured to sell shares at low prices, or even being fired to force them out of the business. Laws recognize that majority shareholders owe fiduciary duties to minority shareholders. This means they must act honestly and in good faith. If these duties are broken, minority shareholders can take legal action. They can file lawsuits claiming breach of fiduciary duty or shareholder oppression. They can also ask courts to buy back their shares at a fair value or, in extreme cases, request the business to be dissolved. Sometimes, shareholder agreements include protections or voting rights that can be enforced in court. Courts often look at what the minority shareholders were promised or expected when they invested. This is called the reasonable expectations doctrine. It helps decide if the treatment they received was unfair or oppressive, especially in family businesses where informal promises and family ties matter a lot. However, fighting unfair treatment is not always simple. Minority shareholders need to document unfair acts carefully and may need access to corporate records to gather evidence. The business judgment rule protects majority decisions unless there is clear proof of bad faith or fraud. Also, some corporate documents include clauses that limit the ability of minority shareholders to bring claims, making it more complicated. Family business disputes are often personal and emotional. To prevent conflicts, it's best to have clear governance structures, detailed shareholder agreements, and open communication. Adjusting voting rules or quorum requirements can give minority shareholders more influence. When disagreements happen, mediation or negotiations are usually better than going straight to court, as they help preserve family relationships and the business. In the end, minority family shareholders cannot always stop unfair treatment on their own, but they do have legal options. Success depends on careful documentation, understanding their rights, and often working with legal experts. Strong governance and clear agreements are key to reducing unfair treatment risks and keeping family businesses healthy and fair for everyone involved.